I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be...
Your Honor.
You have a seat.
I'm not...
Have a seat.
Your Honor, I haven't had...
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself?
I fully recognize and acknowledge the seriousness of the charges, which include allegations of...
Not my question. You understand that there can be serious peril in representing yourself?
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize that.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself? You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be...
Your Honor.
You have a seat.
I'm not...
Have a seat.
Your Honor, I haven't had...
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
If you're finding this story captivating, make sure to hit that like button and subscribe to our channel for more gripping true crime content. Your support means a lot. Thank you.
Good afternoon, Your Honor. Daniel Magoo. Here in Sui Juris.
All right. So on this matter, I was apprised you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it?
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for
charges.
what to occur?
Well, under the rights to due process, Your Honor, Fourth, Fifth, Eighth Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, is not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your
charges.
Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you
You're asking-
believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will, do not interrupt me.
I can object to
Do
that date.
not interrupt. Do not. One more time, you're going. I've given you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may leave
violations.
now.
Let's go. Let's go.
I have a right to a
You may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get want an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
And I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations.
do
That
you
means
wish to be represented by an attorney,
you
sir?
take an oath to defend the Constitution of the United States of
Then
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my court scope.
If you're still with us, make sure to like and subscribe to keep up with more shocking true crime stories. Your support helps us bring these stories to light. Don't miss out on what's next.
Court does call the case of People versus Jadon Marita.
Good morning, Chico, on behalf of Mr. Morita.
Would you state your name for the record?
Jaden.
Judge, today's time and date, we had this matter up before. My client's originally charged with assault and battery. Prosecutors I believe is offering a count 2 of disturbing the peace. My client would like to plead to that, but he's asking if the court would consider a sentence agreement. He's been in jail since this time, which happened on March 20th of 2024. And if he does successfully plead to disturbing the police, I believe that's only a 90 or 93.
I don't know why you're asking me that. I've never done that. 25 years, haven't. So why are you asking me now?
There's always a first time, Your Honor.
Yeah.
People change.
And apparently if you see rainbows and unicorns in the back, it's changed.
Judge,
You see them?
I've noticed as you've got older and more gracious and stuff, you're more open to negotiations.
Older.
Well, I mean, bench wise, not appearance wise.
Older.
I can't save this guy.
Can I have an agreement, old guy? That's what you just said.
No, that's not was my intention, Judge. Listen, I'll be in the nursing home in the next couple of years, so please work with me.
Think it's gonna take that long? No, but.
So that the offer is to plead to act count two, disturbing the peace contrary to section 50170.
We tried that before, didn't we?
Yes, Judge, and you said that we couldn't proceed because there was a victim, but the law clearly states that the prisoner who is in jail, who's the victim, does not have that right except to, may I read this, as an individual who's incarcerated, is not eligible to exercise the privileges and rights established for victims under this article, except for he or she may submit a written statement to the court for considered at sentencing.
And that's correct.
I know that, but thank you for reading it to me.
Thank you.
That still would require, so stay with me here, Mr. Kilwell. If I were to do immediate sentencing, I haven't given that person an opportunity to exercise their right that they do have. Correct?
Correct.
So then if I did that, I'd be violating the statute.
Correct.
Which is what I was saying before. Right?
Correct.
And so now you want me to do what I said I wouldn't do before now.
I should retract that. No, I don't want you. Well, Judge, we'd like to hear the plea today, and whatever the court deems necessary for sentencing, we'll go along with it.
You still want to plead, young man?
I'll leave it to your discretion. Do you want to, they're offering you disturbing the peace. Do you want to plead to that?
I'll plead to disturbance.
You'll plead to that? You understand that I'm going to have to set it out a period of time. I don't know if anybody will respond to any communication or anything, but I have to set it out so that they can at least try to get in touch with the court prior to issuing a sentence on this. You understand that?
Yes. Will I still be able to bond out before?
I'll check on that. I'll check on the bolts while we hear on it.
Oh, God.
He's got other holds, Your Honor.
Yeah. So I don't know that I can answer that anyway.
I'm talking about on this specific case, will I have a bond that where I could bond out?
This bond on this case, what do you have?
It's 1,000%.
So it's $100 bond on this case.
That's it's not going to get any lower.
So I don't, before I was asking if I'll be able to bond out.
Yes, if you pay the $100 on this case, but if you have other holds, you're not going anywhere. That's what the judge is asking. So you still want to plead to disturbing the peace?
You wish to plead?
Yes, Your Honor. So I retract everything I said to you before.
I know, you wasted my time once again. Can I have him raise his right hand to be sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Still wish to plead?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You had previously signed an advice of rights form. You recall doing that?
No.
All right. Because you're pleading guilty, you understand that you'll not have a trial. Okay, because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that? You understand you're giving up your right to appeal of right. Are you on probation or parole? Which one?
Probation.
All right. Were you on probation at the time of this offense? All right. You were?
I was in at the time of this offense. I was already in jail for a probation violation.
Got you.
I think he was pending a hearing on a violation, so he was technically on probation
At the
at
time.
the time of this as well.
Okay, are you still on that probation?
Yes, sir.
All right. You understand that your plea in this case could be considered another violation of that probation.
Yes, sir.
You understand that as such, if it is, that court could sentence you to the maximum allowable under that other charge.
Yes, sir.
And understanding that, you still wish to plead guilty to this charge? Has anybody promised you anything other than what's been stated here today to get you to plead to this charge of disturbing the peace?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes.
Of your own free will? Right, and also because you believe that you're guilty?
Yes.
On the date of March 20th, 2024, at the location of 2201 Hogback Road, that being the Western County Jail, what'd you do that makes you think that you're guilty?
Squirted bodily fluid under inmate's door.
Okay. And in doing that, that disturbed the peace and repose of the area around you? Yes? And you knew that that's what it did?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered through probation. Sentencing on this matter will be
December 17th.
December 17th, 2024, 9 a.m.
And I was able to verify that will be enough time for us to attempt to contact the victim to see if they wish to provide statement.
All right, thank you.
Your Honor, will probation come down to the jail to interview him?
I don't know. Yes, they'll get to him.
All right,
Trust
thank
me.
you. Thanks, Judge.
We do it every day, all day.
What
All right.
started as a routine hearing turned into a cautionary tale of courtroom conduct. The defendant walked in thinking he could control the narrative, but he walked out learning a harsh lesson about authority and respect. Judge Simpson's approach was firm but fair, making it clear that the legal system isn't a game. This case wasn't just about legal procedures. It was about the balance between individual rights and courtroom order. And for anyone watching, the takeaway was undeniable. In the courtroom, strategy can only take you so far. At some point, respect for the law is what truly matters.
Thank you for joining us in uncovering the chilling details of this case. If this story has left you disturbed or reflective, please share your thoughts and reflections. Remember to like, subscribe, and stay with us as we continue to explore the stories that reveal the darkest sides of human behavior. Together, we keep these lessons alive, ensuring the voices of victims are never forgotten. Thanks for watching. Please subscribe or follow.